People of the State of Michigan versus Christopher Gordon. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under the penalty of perjury?
Yes, Your Honor. OB8, of course, is for victim exportation or captivity. A victim was exported to another place of greater danger. I don't think that that's our case. Or to a situation of greater danger. Again, I don't believe that that's our situation here. Or was held captive beyond the time necessary to commit the offense. Beyond the time necessary to commit the offense, not complete, but to commit. And so I just don't see it as being scorable at all. Thank you.
Response?
At the preliminary exam, she went further to state that she told him to stop. He said no, and she had to bite him in order to get away, forcing her to bite him, which means that she was held beyond the time necessary to commit the offense.
Anything further, counsel?
That reasoning suggests that 2 seconds would be a sufficient amount of time to complete the act.
I agree with that.
That would be a sufficient amount of time to complete the act. And it, as we are all instructed, the time necessary to commit the offense, I don't know that there is an exact time to commit that offense, even as described by the 9-year-old.
I think even the Supreme Court has ruled on this. I think it's in the jury instructions. It's no matter how long, it's the touching. So I agree with the people, adopt their argument, and totally disagree with you, but nice try, counsel. It is 15. On behalf of the people, do we have a victim or a representative of the victim here?
We do, Your Honor.
We live in a world where children are further desensitized by traumatic experiences due to no control of their own. Every day, we as adults have a choice in our behavior that impacts the trajectory of our children's lives, both directly and indirectly. I wish that someone loved and protected you when you were sexually abused. I wish that the healing that needs to be done in your family is underway. I wish that my daughter felt safe enough to be in this courtroom to hear you say you're sorry. I wish that your other children can experience real love from a father that cares, supports, motivates, and encourages them to be better for themselves and for their community. I wish that you find accountability within yourself to move forward in life differently. No more running from your problems because you're creating problems for those that are around you. Remember what it felt like to not have someone on your side fighting for you, believing in you. Hiding in your shadows of your truth, only for it to be revealed through your behaviors. I've watched you show up in this courtroom with all the sense I've known you to have, yet no audacity for the table I've extended to you in your times of need. Your slander, the grace, the position and sacrifices I've made for your behalf and your satisfaction. It's very disgusting to be on the opposite end of a lens and watch you in your presence and still hear your lack of remorse you have. I can accept the things that I cannot change. I want to thank you, Judge, for demonstrating patience and understanding in all of those before me as I've witnessed. It's because of your strength and tenacity that I can pull through rough days. As a behavior interventionist from school, I get days off and vacations and time to be away from all the duties of work. It's still a rough job in the schools, but I can't imagine hearing indescribable acts of adults and still having the grace to just be calm and cute. Women like you are inspiring to daughters like mine with the knowledge to lead and excel in all that you do. Showing up is the easy part. Having the tenacity is the admirable act of service. Thank you.
Man, I'm not the strong one here, you are. Stand here, loving your daughter and knowing what you did, and speak on her behalf. That's a true hero. And that's what you are, you're the strong one. And your daughter has just an amazing role model. And the reason she's going to get through this is because of you. Now, is the restitution that you're seeking, is she in therapy? Is there any money that you are spending because of what he did?
No.
Okay. I am going to order, if it's okay with you. I've done this many times. As far as I know, I'm the only judge that does it. At some point, maybe somebody will tell me I can't do it, but I really don't care. I'm gonna keep doing it. I'm gonna order a copy of this transcript. If you would like, you can also have a copy of the plea transcript. The reason I do that isn't to hurt you or your daughter, but as your daughter gets older, and she's certainly going to remember these events, she's going to need her own therapist, who I call a secret keeper. So she can have a conversation to know that her mother spoke on her behalf, that her mother stood up for her, that the court listened, the prosecutor listened, and that justice, as good as it can be, can't return things backwards, but it can change her life and the life of others because of you and your daughter speaking up. He cannot offend anyone else, at least while he's in lockup, and we're going to try to get him some treatment. So I want to know her to know that she was heard. And I believe that a therapist is only as good as the knowledge they have. So this would be given to you in a sealed envelope. If you want to read it, that's fine, but I would suggest that you only reveal it to her therapist and to her when she's of age, so that it can be used in her therapy to help her become whole and happy, know that she is clean and safe, and she did nothing wrong, that he did everything wrong, and that you also did everything right. So is that all right with you, ma'am?
Yeah, sure.
Okay, so the crime victims unit will be giving that to you.
Yes.
I really, really appreciate your strong voice and you protecting all our kids, because when you report, when you stand up and say no, then you are the example for others who don't have that strength. So you and your daughter are both heroes. Thank you for being here.
The plea bargain was made in contemplation that dismissing one count of CSC 2 would drop the guidelines to 29 to 57. I did not realize there was a juvenile history in Florida that I had some of, not all of it, when we calculated the guidelines. So the probation department found a little bit more. That's what made the guidelines ultimately 36 to 71. I think there's a new case and a new court rule that indicates that although that might not be part of a plea agreement, which it was not, that if it's explicitly articulated that it is the motivation for the plea agreement, that that it might as well have been part of the plea agreement. So I'm going to ask the court to sentence the defendant within the range of 29 to 57 months. I'm actually going to ask the court to sentence him at the top of the guidelines to 57 months, because ultimately I think that's fair. That's what we thought the negotiated plea agreement was going to have the guidelines as. That's what I consulted with Mrs. Houston about. But I think the law actually requires that. So I'm going to ask the court to sentence him to a sentence in the Michigan Department of Corrections of 57 months to 15 years with credit that he's entitled to. That also will require lifetime electronic monitoring is already on there.
Being a parent myself, I absolutely can understand and appreciate Ms. Houston and her position. She's here acting as an advocate on behalf of her child. I agree with the comments and sentiments offered by the court. I say that to now say this. Based on my reading of the pre-sentence investigation report, particularly on page 5, the daughter was admitted to the hospital for UTI, urinary tract infection. I cannot imagine how that is associated with this case.
Because UTIs, every woman knows, I suppose men don't know this, but UTIs are, especially in children, are an indicator that there may be sex happening, and newlyweds get UTIs all the time. I mean, ask every hotel that has a newlywed suite, they have a doctor who's seeing the newlywed. That's why.
Yes, Your Honor. And this is a criminal sexual conduct in the second degree, where it's undisputed that the child was fully clothed.
I got that.
Okay.
But as a parent, and you just said you're a parent, I would have the same exact concern. Is there something else going on that I need to know about? And there's lots of medical reasons that happens, but there's also sexual reasons and concerns. So as a parent, I think it's right for her to go through that thought, to go through her mind and to go through those machinations of how did she get this? So I don't fault her. It's not something I'm considering. I'll just say that for the record. Thank you.
In the process of completing his general education degree, he has completed the PATS coping skills program. He showed the probation agent certificates of completion that was also included an anger management class, some mental health issues, and employment. So he has taken it upon himself to try to rehabilitate himself while he has been incarcerated, and I think that is something of significance for consideration. With respect to the actual sentence imposed, I know that my client is going to speak to the court in just a moment. Respectfully, 36 months to 180 months, if that would please the court.
Thank you. Sir, what would you like me to know?
Well, I do apologize for my negligence and not being able to make her feel comfortable to come to me and talk to me about that.
I didn't get that. And not being able to make what?
Not making her feel comfortable enough to come tell me what was going on.
You mean the little girl?
Yes.
Wait a minute.
And,
You're apologizing for negligence for her not telling you what was going on when you are trying to have sex with her, although fully clothed? Is that what you're telling me?
no, that's not what
Then explain what you mean, sir.
just me being a father, I haven't made her feel comfortable to tell me about what's going on because I didn't.
Why do you think a victim has to tell you what's going on?
Okay.
You're the adult, you know what's going on, and you knew it was wrong. No means no. She had to bite you to stop. She did tell you, and you didn't stop, and she bit you. I'm not understanding this at all. I don't think you learned anything from those classes.
I have learned from my classes, Your Honor.
Then speak in English or make up a different story, because I'm not believing a word coming out of your mouth.
I just really apologize for my negligence.
Sir, you are 33 years old.
Yes, Your Honor.
Sorry, I don't understand.
Sorry doesn't understand now. All right, look, you're 33 years old. You have a criminal history that I could wallpaper a room with. You have a juvenile history that's extensive. Granted, a lot of things were dismissed. I don't know what happened there. There's lots of reasons things get dismissed. But then you don't get so lucky. In 2011, you have resisting an officer. Again, you have dismissal of very serious charges. I don't know. So you're presumed innocent, but when I look at this pattern here, some more assault of crimes that are dismissed, and then you have drug possession.
That too was also dismissed.
You what?
That too was also dismissed.
I have 60 days jail, fines and costs, so it wasn't dismissed. Controlled substance possession.
They didn't charge me. That was thrown out.
Not what it says here. Do we need to amend this further? What was this counted?
Which count, I'm sorry.
7 of 12 in 2022. He had a possession of a controlled substance.
Well,
Looks like it was a plea. 60 days jail, fines and costs.
I can tell you that I verified it in the lien because that's how I knew to have you do the correction assigned counsel.
Yeah.
It shows as a plea in the lien.
Then we have a theft of a vehicle, which just was dismissed. And then in 2023, we have resisting arrest, fraud impersonation, fleeing, eluding, driving while license suspended. Not the worst crimes I've seen, but there is an escalation that I'm seeing. Because then we go to aggravated assault weapon. And then we have another thing that's dismissed. Now we have the biggest one. And what really, really concerns me, defendant denied that he is interested in any fetishes, voyeurism, attraction to pre-pubescent females, males, or anything else he felt worth noting. Well, we have a pre-pubescent female here. You admitted to it, but you deny it here. I don't think you are being truthful nor truly accountable. I appreciate that you've done some work while in jail. You have not been idle, but the work that you need to do is on the criminal sexual conduct. And sir, I don't like this deal. I don't like these guidelines. I do have the ability to sentence you 10 to 15. That would be 120 months to 180 months. And that's what I feel like doing. Because you weren't getting it. And because I believe that you need more time. However, because of this guideline debacle, and because I don't want this little girl to have to face a trial when the Court of Appeals tells me to resentence you, or you can withdraw your plea, all the other things, I think the family needs closure. I think mom's going to get the help her daughter and her family needs. So I'm going to sentence you to the Michigan Department of Corrections for 50 to 57 months, which is the high end of the guidelines of what was anticipated and contemplated and discussed. 57 months to 180 months. You have credit for 650 days. You have lifetime electronic monitoring. You comply with SORA. You'll have no contact. You communicate with them directly, indirectly, through third parties. You get creative and send a Christmas present, a Hallmark card, flowers, carrier pigeon, message, smoke signal. You communicate in any way, shape, or form. I will contact the warden, and they will not allow you to have any communication. All your friends and family, if there are any who want to see you, will have to come see you wherever you are so situated. So don't tempt your fate, sir. You are going to pay for the costs of the plea and sentencing transcript. That is for the rehabilitation, health, welfare, safety of the little victim whose life you altered forever. She is no longer that innocent 9-year-old. Not only does she know things a 9-year-old should not know, but she lives in fear. God granted her a strong mother. And I believe that she will be healed, because she will never forget. And that trauma will live inside her and will rear its ugly head at times when you least expect it. And you caused that. And you had no right to cause that. No right to affect another human being. Is there anything else I need to address?
No, Your Honor. Thank you.
Oh, there is. He has to pay $130 crime victims and $68 state cost.
For the record, I'm handing my client a notice of right to appellate review.
Sir, you have 42 days to appeal and to request appellate counsel.
You acknowledge that I gave you that form.
To appeal.
To appeal, if you would like to appeal this, that's how you do it. You only have 42 days to read it and consider it and fill it out. You understand?
Yes. Yes, Your Honor.
Any questions?
No, Your Honor.
In this sentencing hearing, the court addresses Christopher Gordon in a criminal sexual conduct case involving a 9-year-old girl. The proceeding begins with an argument over the scoring of an offense variable. Defense counsel argues that the aggravating factor for victim asportation or captivity should not apply because the victim was not taken to another place of greater danger, not put into a more dangerous situation, and not held captive beyond the time necessary to commit the offense. Counsel maintains that the facts simply do not fit that enhancement and asks the court not to score it. The prosecution responds by relying on the preliminary examination testimony, pointing out that the child said she told Gordon to stop, he refused, and she had to bite him in order to get away. According to the prosecutor, that means the child was held beyond the time necessary to commit the offense, making the score appropriate. Defense counsel pushes back, suggesting that under that logic, almost any touching could be stretched into captivity, and argues there is no exact amount of time required to commit the offense. The judge ultimately sides with the prosecution, says she adopts their argument, and scores the variable at 15 points, while jokingly telling defense counsel that it was a nice try. The court then turns to victim impact, asking whether a victim or representative is present. The child's mother speaks on her daughter's behalf, and her statement becomes one of the emotional centerpieces of the hearing. She begins by reflecting on how children are forced to live with trauma caused by adults who choose harmful behavior. She tells Gordon that she wishes someone had loved and protected him when he himself was sexually abused, and she wishes healing could begin in his family. At the same time, she speaks directly from the pain of her daughter's experience. She says she wishes her daughter had felt safe enough to sit in the courtroom and hear him say he was sorry. She says she hopes his other children can someday experience genuine love from a father who supports, motivates, and encourages them rather than creating more harm. She urges him to find accountability within himself and stop running from his problems, because in doing so, he only creates problems for the people around him. The mother continues by telling Gordon to remember what it felt like to grow up without someone on his side, without someone fighting for him or believing in him. She describes him as someone hiding in the shadows of his truth, only for that truth to reveal itself through his behavior. She says she has watched him come to court with all the sense she knows he has, yet with no respect for the grace, support, and sacrifices she had extended to him in times of need. She says it is disgusting to now be on the opposite side of things and still hear such a lack of remorse from him. Even so, she says she is learning to accept what she cannot change. She thanks the judge for her patience and understanding, saying that seeing the court handle these painful matters with strength helps her endure her own rough days. She describes herself as a behavior interventionist in a school, someone who works a hard job with children, but says she cannot imagine hearing the terrible acts adults commit and still maintaining the calm and grace that the judge does. She tells the judge that women like her are inspiring to daughters like her own because they show what it means to lead, excel, and endure. The mother's statement is not only an expression of pain, but also of protective love and moral clarity, and it makes clear the deep emotional damage the offense has inflicted on the child and the family. The judge responds to the mother with warmth and admiration, telling her that she is the strong one. The judge says that standing in court, loving her daughter, knowing what happened, and speaking on her behalf makes her a true hero. She tells the mother that her daughter has an amazing role model and that the reason the child will get through this is because of her mother's strength. The judge then asks whether the family is seeking restitution and whether the child is in therapy or whether there are expenses tied to what happened. When the mother says no, the judge raises something she says she has done many times before, even if she is not sure other judges do it, or even if someone someday tells her not to. She says she is going to order a copy of the transcript, and if the mother wants, she can also receive a copy of the plea transcript. The judge carefully explains that she does not do this to hurt the mother or daughter, but because as the girl gets older and inevitably continues to process what happened, she will need her own therapist, someone the judge refers to as a secret keeper. The judge says that the transcript can one day help that therapist understand that the girl's mother stood up for her, that the court listened, that the prosecutor listened, and that justice, while never able to undo what happened, can still matter. It can show the child that she was heard, that adults believed her, and that action was taken because she and her mother spoke up. The judge goes on to say that while the sentence cannot reverse the past, it can at least stop Gordon from offending someone else while he is locked up and perhaps get him treatment. She says she wants the girl to know she was heard, and that a therapist can only be as effective as the information available to them. For that reason, the transcript would be provided in a sealed envelope. The judge suggests the mother keep it private and reveal it only to the child's therapist and to the child herself when she is older. She says the purpose is to help the child become whole and happy, to know that she is clean and safe, that she did nothing wrong, and that Gordon did everything wrong. The judge tells the mother that she also did everything right. She then says the crime victims unit will provide the transcript and thanks the mother again for protecting not only her own daughter, but other children as well. By reporting and standing up, the mother and daughter have become examples for others who may not yet have that strength. The hearing then shifts back to the legal framework of sentencing. Defense counsel explains that the plea bargain had been negotiated with the understanding that one count of second-degree criminal sexual conduct would be dismissed, which in turn was expected to lower the sentencing guidelines to a range of 29 to 57 months. However, after the plea was made, probation uncovered more of Gordon's juvenile history from Florida than counsel had originally known about. That additional history raised the final guideline range to 36 to 71 months. Defense counsel argues that although the exact guideline calculation was not formally written into the plea agreement, it was clearly part of the motivation behind the plea and therefore should be honored in spirit. Counsel says that everyone had negotiated the plea believing the range would be 29 to 57 months and that this understanding had been communicated to the victim's mother as well. For that reason, defense counsel asks the court to sentence Gordon within that originally contemplated range and specifically asks for 57 months to 15 years in the Michigan Department of Corrections, with whatever jail credit he is entitled to. Counsel notes that lifetime electronic monitoring will also be required. The defense then tries to present mitigation. Counsel says that as a parent, he can understand the mother's position and that she is acting as a proper advocate for her child. He also references the pre-sentence investigation report and points out that the child had been admitted to the hospital with a urinary tract infection. He begins to suggest that the UTI may not necessarily be connected to the case, arguing that UTIs can happen for many reasons and making an awkward comparison to newlyweds, apparently trying to minimize any assumption that it proves additional sexual activity beyond the conduct already admitted. The judge quickly cuts him off. She reminds counsel that this is a second-degree criminal sexual conduct case involving a fully clothed child, but says that from a parent's perspective, it is completely natural to hear about a UTI and wonder whether something more happened. She acknowledges there are innocent medical explanations, but also sexual reasons why such a symptom could be alarming. The judge makes clear she does not fault the mother for having those fears, and says for the record that she is not considering the UTI as a sentencing factor. Counsel thanks the court and moves on. Defense counsel then emphasizes Gordon's conduct while incarcerated. He says Gordon has been working toward his GED and has completed coping skills programming. He has shown probation certificates for anger management, mental health work, and employment-related efforts. Counsel argues that Gordon has tried to rehabilitate himself while in custody and that these efforts should count in his favor. On that basis, and while acknowledging Gordon will address the court himself, counsel asks for a sentence of 36 to 180 months if it pleases the court, effectively requesting a lower minimum than the prosecution sought. When Gordon is invited to speak, his statement immediately goes badly. He begins by saying he apologizes for his negligence and for not being able to make the child feel comfortable enough to come and tell him what was going on. The judge stops him and presses him to explain what he means. Gordon repeats that, as a father, he had not made her feel comfortable enough to tell him what was going on. The judge rejects this entirely. She tells him the victim does not have to tell him what is going on because he was the adult and already knew exactly what he was doing. She reminds him that no means no, and that the child did tell him to stop, and when he would not stop, she bit him. The judge says she does not understand his statement at all and concludes that he clearly has not learned anything from the classes he has taken. Gordon then tries to shift and says something about his past, but the judge is no longer persuaded. She tells him to speak plainly or come up with a different story because she does not believe a word coming out of his mouth. He tries again to apologize, but the judge cuts him off and turns to his record. She says he is 33 years old and has a criminal history so extensive she could wallpaper a room with it. She notes his juvenile history is substantial, even if many charges were dismissed, and says there are often many reasons charges get dismissed, but that does not erase the pattern. She references a 2011 resisting an officer conviction and other serious charges that had been dismissed. She notes another drug possession matter, and when Gordon interrupts to say it was dismissed, the judge checks the record. She asks for clarification about a 2022 controlled substance possession case, and it appears from the record and lien verification that there was in fact a plea resulting in 60 days in jail, fines and costs rather than a dismissal. Gordon continues trying to contest parts of his record, but the judge is not persuaded. She then walks through the broader pattern she sees. A theft of a vehicle charge that was dismissed. Then in 2023, charges involving resisting arrest, fraud, impersonation, fleeing and eluding, and driving with a suspended license. She says these are not the worst crimes she has seen, but they show escalation. And that escalation becomes more concerning when it leads to aggravated assault with a weapon.